Now, we're back to the drawing board. That is probably the statement that is lingering in the minds of the Supreme Court judges as they prepare to hear yet another presidential petition in 2 months. Well, this time, the bench presided over by the Chief Justice David Maraga will hear 2 petitions seeking to nullify the October 26th election that saw President Uhuru Kenyatta declare the winner with over 98% of the votes cast. Like the petition that nullified the August presidential 8th election, the 2 petitions are not challenging the numbers of the votes that Uhuru was able to garner, but the legality of the electoral process. Well, it is a deja vu scenario. To answer that question, in studio, I have lawyer Agostino Neto, who is also the immediate member of parliament for Ndiwa, and he's also a lawyer. Thank you very much for joining us on the show.
Thank you very much.
All
nice being here.
Great. We'll also be joined from our City Centre studio by Paul Wathuta, who is also a lawyer. He's going to be joining us from that end in a few moments. But before that, let me just hear the thoughts of lawyer Agostino Neto. Thank you very much for joining us. So what can you say about these 2 petitions before the Supreme Court?
I think most Kenyans have not paid so much interest and attention to the petitions, simply because the persons who filed the petitions might really not be known by very many people.
Right.
Save for Honorable Harun Mwau. But I really think that the petitions raise real pertinent issues of law, and I think they're very interesting because one of the things that you've said properly when you're introducing this show was that the elections do not dispute the number of votes, for example, that President Uhuru Kenyatta got or garnered during the election. But I think most of the petitions are premised on Section 83 of the Elections Act, which says, that despite the fact that the law was not followed, it does not matter whatever results it is, so long as the election was conducted in a manner that the result would have been prejudicial. So I really think that it's a pretty interesting, they're 2 pretty interesting petitions, almost having similar path in terms of what they seek to do. In August, the August petition that was filed by NASA was seeking to nullify the presidential election because of the transmission of election results.
Yes.
For them, they were saying that the law wasn't followed with regard to the transmission. But this one is these 2 petitions are very curious. One, they are speaking to the fact that they think there ought to have been nominations.
Yes.
As a precursor to the conducting of a presidential election.
Right.
So in their view, the fact that no nominations were conducted, then it stands to say that the people who were then actually on the ballot were not validly, could not validly be elected.
Right.
They're arguing that the nominations is a part of the presidential election continuum, that it is an act that is precedent. You cannot purport to, for example, say you're going to conduct an election without having conducted
Nominations, right.
The argument is very interesting because they're saying Article 143 of the Constitution nullified the presidential election, which means the entirety of everything else that happened before that election of October 26th cannot have been used anymore. So that means that anything else would have been started afresh. But in their view, IBC did not really think that should have been done. So it's a pretty interesting thing.
All right. So I want us to get deeper into the petitions before the Supreme Court judges. But just before that, when Justice Maraga was ruling, and nullifying the other election, well, he said very clearly that if this 26th October election is not done properly, that will still go back to the court. Is this something really, and reading from the mood of the country, and I don't think that the Supreme Court can really differentiate itself and remove itself from the mood of the country, the political environment, and the fact that we've been in this environment for such a long time. Are they likely to grant the petitioners what they want and see Kenya going into another election?
I like the question you're asking me, but as a lawyer, I would walk away from that part. Because you want me then to discuss the merits of this particular case. But let me just say something, that whatever the outcome of this particular presidential petitions, they are very interesting. I've read the entirety of the two petitions.
Yes.
Whatever they do, whatever the outcome, I think they're going to help in developing our law. What are they seeking to do? First, the petitions have distinguished two things. Under the presidential petitions, you can have a presidential rerun under Article 138(5) of the Constitution. Mm-hmm. What does that mean? Assuming, for example, there were 10 candidates who ran for president, and then none of them got the 50+1 threshold that is constitutionally anticipated, yes, as well as the 25% in half the counties, then you then having something called a rerun election. In their view, they're saying that the petitioners are saying that that particular rerun is a continuation of the first election, because we're only saying that the election hasn't stopped. We are continuing from where we started, just that no one got the constitutional threshold. But the petitioners are saying that what happened on August the 8th and the subsequent nullification on September the 1st was a fresh election. That means that every actions that happened subsequent to September the 1st, yes, were nullities. It is going to help build our jurisprudence. Whatever the judges see, it is going it speaks to two things. Article 137 of the Constitution, it talks about the procedure for nominating presidential candidates, but also Section 14 of the election laws. The petitioners have done a very interesting juxtaposition. I mean, they say that the nullification of an election, whether it be a presidential election, a member of parliament election, a gubernatorial election, you see, in the cases of the gubernatorial election or the presidential, the parliamentary election, a nullification means that you start afresh. You see political parties coming up, nominating their various candidates, and various candidates different from the ones who participated in the nullified election coming up and participating. Yes. So in their view, they're saying that is what should have happened, that a presidential election does not distinguish itself from the other tier election, so that they want the Supreme Court to agree with them that a presidential election is not anything different, nothing new. Right. The only thing is that the person who listens to the petition is the Supreme Court, as opposed to the various tiers of the election. So whatever the decision or the outcome of this particular petition, I really think it is going to put Kenya again on a very interesting path of jurisprudence.
All right. And speaking about, the place of the Supreme Court judges, and at that time after they made that decision to nullify the election, the people who were criticizing the judges and saying maybe they should have given more direction, and then we would not find ourselves in this situation. More direction in terms of, what did they mean, with illegalities and irregularities? Who should have gone home? Maybe the question to do, of course, fresh nominations. Maybe they should have gone a bit further in really giving direction as to how this October 26th election should have been carried.
I really think that's one of the things that the petitioners do nuance in their petition, and they're saying this, that it is not for the Supreme Court to give directions or order. The IEBC on its own motion is an independent institution, so that the Supreme Court judges are hoping that what they needed to do was to nullify the election and ask the IEBC and the chair of the IEBC to conduct the election in accordance or in adherence to the law. Now, the petitioners are arguing that IEBC was at fault. Should they have been in doubt? They criticize IBC on three grounds. The first one, they're saying that, there had been an adjudication of the Honorable Jirongo as having he had been adjudged bankrupt a couple of days before this particular before the particular nominations for presidential elections were happening. But that IBC of its own motion, in a non-transparent manner, still had Jirongo's name on the ballot paper. Ordinarily, that should not happen because, if you've been adjudged bankrupt, that is ground enough for disqualification. But they're saying in a non-transparent manner, IBC then proceeds to gazette Jirongo. But the second thing that they're saying is that, the Supreme Court is open, apart from, for example, listening to presidential petitions. The other thing that the Supreme Court ought to do is giving advisory opinions, so that IBC is being faulted to the extent that should they have been in doubt? IBC did two things which were really grotesque and I think totally uncalled for. One, they proceeded on what they were saying was the Raila court decision of 2013 by so using that particular court obiter. The reasoning of the court in 2013 to gazette only two presidential candidates, which in itself was unprecedented, because that can only happen within the meaning of Article 138(5) of the Constitution, where there is a rerun. So the petitioners are saying, if the IBC were in doubt in terms of how to proceed, they should have then proceeded to go to the Supreme Court for an advisory opinion, because they're saying Section 14 of the Elections Act is one that says a nomination and a gazettement of candidates should happen in 21 days before an election. 60 days that the Constitution sets still is a lot of space. There's a lot of latitude within which IBC could have played with, so that they cannot be saying that 6 days could not be expanded, because the law only anticipates an gazettement in 21 days. They're faulting IBC for not having sought an advisory opinion while they in doubt, and they're thinking that that particular act was either negligent or deliberate. And if at all it was negligent, that means then they did not proceed in accordance with the law. If it was deliberate, then that means again they went against what the Supreme Court had anticipated with regard to not having followed the spirit and the letter of the law in conducting the elections.
All right, let's talk about the arguments that Njonjo Moe of ICJ and Kelef Khalifa of Muhuri are bringing about, and they're saying that this particular election, the 26th one, was a shambolic mode of exercising a democratic right for Kenyans. How would they be able to substantiate that?
I think one of the arguments that they say, Article 138.2 of the Constitution, 138.1 first says that there ought to be nomination of candidates, which is one of the things that that runs across both the Khalifa petition and also the Harun Mau petition. That one, Article 138 talks about nomination of candidates. But two, where two candidates or so are validly nominated, then an election shall be conducted in each constituency. So that is one of the things they're saying. So they've listed 27 constituencies, some of them in Nyanza, and I think other parts of, the coast region, which they're saying that an election did not happen in each of those constituencies. In their view then, Article 38 of the Constitution with regard to free and fair elections. In fact, they cite various international instruments, the Universal Declaration of Human Rights, the International Covenant on Civic and Political Rights, which are all legal instruments, which are all legal documents which show how elections ought to be conducted. So in their view, because some people were disenfranchised, some of them, they're saying 27 constituencies did not participate, but two, that there was violence, there were protests where, in a sense, some IBC officials were ejected from their polling centers. There were conditions given to commissioners, so that one, they're saying the commission or the commissioners were then not acting independently because there were several underhanded dealings, there were conditions coming from all sectors. Two, sections were, they claim IBC balkanized sections of the country, and balkanization then was denying them their right to vote, which is an Article 38 constitutional right, but also articles that are in several conventions which Kenya are party to. So they're saying that particular disenfranchisement of not participating in some constituencies, balkanizing sections of the country, and saying that they're not going to, they postponed twice the elections in those particular areas. But the third one also, they're saying there are particular constituencies that started voting when counting had already started. So they're saying, it was prejudicial that how do you have us vote when you've already announced sections of other voting in other constituencies. In other words, you're telling us there's already a predetermined outcome of this particular election. So I really think that in their view, they could not then have been free and fairness, because then, one, there was an undue advantage with the results having been announced. Two, the interference of IEBC in terms of IBC looks like it was topsy-turvy. I mean, in one instance, they were saying that, we cannot give you assurance that this election is going to be free and fair. And on the other hand, IBC again was, in its own motion, was having internal wrangles, which they claim, and they also document very well, that there was discordance and disharmony in IBC. So in their view, they really think that the commission, as it stood as of October 26th, cannot have been independent to run an election.
All right, wow. You've really put it so clearly. So going back to the August 8th election and why it was nullified, what differences then can you make between the petition at that time and what we're experiencing now? Is it going to be the same thing to do with irregularities and illegalities?
Two things have happened. There was an election amendment law that was made. Of course, it was subsequently gazetted, I think 2-3 days ago. Now, what is indicative, and which is one of the things that these particular petitions are asking, the Njonjo Moe and Khalifa petition is requesting to the court to apply its mind to. Section 83 of the Elections Act, before it was amended, said that, so long as an election was not done in accordance with the law, it does not matter as to whether it could have affected the outcome or not. But now, subsequently, that particular section has since been amended, which means that they're asking the Supreme Court to say, what this petition that we brought before you, what is going to be the space of Section 83 that was amended? Are you going to apply the law of Section 83 before, as it was before it was amended, which meant that anything else that was done not in accordance with the law would then declare an election a nullity? If that will be the finding of the Supreme Court, then what that would mean is that, yes, the Supreme Court will then find that there were legalities and irregularities that would have affected the outcome of this particular election. But should the Supreme Court, for example, proceed that right now there's an election law that is existing, which means that despite the fact that there could have been irregularities and illegalities, that if at all it did not affect the outcome of the election, then that election then is not vitiated, then I really think that the Supreme Court will then hold that this election can then still stand. So that is what the Supreme Court, first of all, has to apply its mind to. One, whether Section 83 of the Elections Act, as it is then was, is then applicable to this particular petition. If they find that it, as it was, is applicable, then I think they will find that this election was not done in accordance with the law. But should they find that Section 83, since having been amended, creates fresh parameters, then again, that is for them to determine what's going to happen. That's the first thing. That is different from what happened in the August 8th petition and what is happening right now. But the second thing, you see, in the August 8th petition, they were talking about transmission of results.
Yes.
So that, if transmission of results would then be mirrored as to the law as it is right now with the amendment of Section 83, then that would not stand. That particular election petition of August 8th will not stand within the view of this particular law. But what is the problem with this particular petition? Despite the fact that Section 83 of the elections law can be found unconstitutional, like the one the courts to find, there's a fresh problem. They're talking about the validity of a presidential candidate. If you're not valid, that means you cannot present yourself for election. So it does not even matter that the law was followed or not. It talks about you being you having sufficient competence to be elected. Now, Section 137 of the Election Act, Article 137 of the Constitution says, for you to be validly put up a candidate for an election, you need to be nominated. Now, they are seeking to ask the court if the nomination that happened to President Uhuru Kenyatta and the other 8 candidates before the August 8th, if at all it was still valid to be used in the October 26th election. In their view, it cannot happen since Article 143 says once it's null and void, you're going for a fresh election, which then means the whole process starts afresh. Wow. So if at all, for example, we will find that the whole process should have started afresh, then it simply shows that the people who brought themselves as candidates, Ukora Aukot, Professor Kanyiga, and Uhuru Kenyatta, could then not have been validly elected because we do not know whether the papers that we're using now on October 26th were clearly authenticated by the IBC. That's the first thing. But the second thing, they ought to have been paying a certain fee, 200,000 Kenyan shillings.
Yes.
So if they did not pay that particular fee, could they then have proceeded in the manner that the Constitution Article 137 anticipated? So essentially, they're saying that what we had in October 26th cannot have been election. Because these people are participating. How did they get here? Just like, I cannot be a news anchor in KTN because I'm not an employee. So how can you then play here if at all you're not? You do not have what is requisite. And so I really think it's a pretty interesting one. So it has nothing to do with the laws not having been followed. It is more with the validity of the candidatures. Because two things. Apart from the nomination having not happened, the second thing that they raised, which I spoke to earlier, was the fact that Jirongo having been adjudged bankrupt, how then in a non-transparent manner do you bring him back to the ballot? And look at the various things that the IBC did. The IBC did 2 very interesting things. On the one motion, they did purport to nominate candidates outside the stipulated legal timeline. The stipulated legal timeline is 21 days to an election. They're saying that IBC just nominated the candidates. If at all what they did in terms of gazettement was a nomination, they did that 13 days to an election. Essentially, they're saying they disenfranchised the candidates by making sure that they had very few days to campaign.
Right.
So they're saying that, look, on the one hand, you have two candidates who've been brought in afresh, 2 days to an election. You have five people having been there earlier. So what is this that we're engaging in? How can this then stand at the threshold of a free, fair, and transparent election?
Wow. Interesting. So I want to bring in now Paul Wathuta, who's a lawyer, joining us from our City Centre studio. Also, let's just hear your thoughts on this one. What differences can you draw? Hopefully, you've been able to look at the petitions before the Supreme Court. What differences can you make between these petitions and what we saw on after the August 8th election?
Yeah, thank you, Betty. I've had a chance to look at the petition as well as the earlier petition for the election of August. But even before we engage in any discussion, let us also remember that this is a matter that is pending in court. So we may not be in a position to discuss the merits or the demerits. However, the petition is basically based on what my learned friend has just talked about, the issue of nomination, among other issues. And these are matters, much as we may engage in this discussion, ultimately it's a court that will determine whether they are worth nullifying the election or not.
All right, but just looking at some of the arguments that have been brought forward, with the one of the issues really is to do with the fresh nominations, that the candidates didn't pay for the to be part of this particular election, and also it brings in the issue to do with Jirongo, who had been declared bankrupt but was still on the ballot. From all these things, what do you think that this is a solid case that would foresee a nullification, even as you say that you still cannot really completely speak on this particular issue as it is before the court?
My view is that there's no case that is too good to be won, and there's no case that is too bad to be lost. And these are the materials that will be placed before the court, and the court will weigh and see whether there are sufficient reasons to nullify an election. The question will be, do they amount to does that render the election fall short of the constitutional requirements, as well as affecting the result? That's all.
All right. Now, in this particular one, the petitioners really are not going against the numbers. Just as it was a situation back in August 8th, they're really going through and, putting the focus on the process. What do you make of this?
No, that is exactly the shift between the election that was held in August and the subsequent petition and the current petition. The numbers, the court in September made a conclusion that really numbers do not matter, but the process matters. These are matters that the court will interrogate. But what I would want to point out, the court will be required to apply the Constitution. Was the election free, fair, and credible? And then, in case there were any shortcomings, and I'm not saying that there were any shortcomings, they will be weighing those shortcomings, if there be any, to confirm if they indeed affected the result. Ultimately, Betty, an election is about the result, and that is the reason why a petition is filed after a result is declared.
All right, but is it about the result really, or even with the process?
It's also about the process. That's why I said I would be hesitant to discuss the merit and the demerit of both sides' case. At the moment, we have not seen any response from any of the respondents. So if we discuss, or if we talk about how they will respond, we will basically be speculating. But they have up to Sunday to file responses. So I think at that point is when we can see what they are saying about these issues that are raised.
All right, let me come back to Agostino Neto. Let's talk a bit about the IEBC. And even before we get to the issues, first of all, they dropped the two lead counsel. Well, might this have been informed by what happened on August 8th?
I mean, I think IBC is entitled to its choice of counsel. And I really think that for you to be, I think there's always a bid or something. The IBC always has a role of lawyers or a role of advocates that they can always use for depending on which case they want to do and depending on the strength and competence of the advocates. So I really did not know what informed their decision to change or shift the advocates with regard to this particular petition.
Interesting. All right, still on the IBC, didn't they foresee that, even this Harun Moa petition, it was there even before the August 26th election. Didn't they foresee that there could be an issue to do with the nominations and the candidates and everything that is being raised about the candidates themselves, not even the process?
I mean, I would like to talk about the IBC, and of course, you notice my colleague Paul is been fairly very careful in terms of how much content you can discuss with regard to whether they violated the law or not. I mean, but what I'll be speaking to is more like what is the content of the petition, and whether it has merit or not is another story altogether.
Right.
But you remember that there was a judgment of the High Court which said that IBC erred in terms of just gazetting two presidential candidates only, as opposed to having the entire team of people. So that was already a court decision, which has nothing to do with what is the merit of this particular case. So I really think that, like I told you when I was starting this particular discussion, is that, look, it does not matter whatever the outcome of these particular petitions are. What is going to be important is the place at which they put the Kenyan jurisprudence with regard to elections. Because two things come out very clearly. When the IBC has been told, if at all in doubt in the future, the Constitution is very clear with regard to how you proceed when in doubt. And that is seek an advisory opinion of the Supreme Court with regard to what is the next step. We're not very clear here. So shall we just proceed in darkness, or shall we then use the institutions that are constitutionally put in place? You appreciate that the Supreme Court, the IEBC, Parliament, amongst others, are organs of the election. So that the organs of the election ought to be speaking to each other in a manner that is concomitant and acts in accordance with election issues. You notice that the Parliament just made amendments to the elections laws, which IBC or the Supreme Court said could have raised issues. You understand? So it is this kind of a continuum or this sort of process that the institutions of Parliament, the institutions of IEBC, the institutions of the Supreme Court exist so that they respond to election issues, so that, you do not proceed on your own motion, thereby conducting illegalities. So I really think that it is going to be a cautious thing for whoever becomes the commissioner of IBC in the next election, whoever becomes members of Parliament in the next election, that, look, whenever in doubt with regard to issues with elections, seek an advisory opinion. And once you've sought an advisory opinion, then know how to proceed. IBC maybe negligently, like the petitioner says, or deliberately proceeded without seeking opinions, which would be, one, make this particular election prejudicial should the court find it that way, which I think ought not to have happened. Having been given directions and ordered to conduct an election in conformity with the law, I would have been a little bit more careful and a little bit more cautious. And I've looked at every little detail of the spirit and the letter of the law in a manner that, for example, then there would be no issues. I mean, look, if someone is saying, for example, you ought to have conducted a nomination, you have 60 days. What was so difficult in seeking a Supreme Court advisory opinion so that should, for example, that Supreme Court give you an opinion? You're back there now. You're telling them, we acted on the basis of your opinion. We came here before this court. We were not clear in terms of what to do with regard, because Kenya has never had a nullified presidential election before. So this was definitely a new terrain. And the law here was also fairly not very clear. So I think there's nothing wrong with seeking opinions, which I really think they either negligently or deliberately sought not to do, which I really think is going to be good, because how this petition proceeds is going to be helping strengthen our institutions.
Okay, interesting. Wathuta, what do you think about that? I mean, there's a point that, Wafula Chebukati moved to the Supreme Court, to seek direction on, his hand and, what exactly his role is with the final results, if he should be able to verify, to alter or do anything. And he moved to the Supreme Court right before the October 26th poll. Do you think that he should have sought more, advisories with regard to all these issues that are now coming up to do with the fresh nominations issue, maybe, moving forward before the October 26th poll?
Let us first commend IEBC for seeking the guidance of the court on the issue of verification, because one of the reasons why the Supreme Court nullified the election was because it was said that IEBC failed in its duty to verify the results that were coming from the constituencies and also the polling stations. If you just look at that question and the fact that the chairman cannot amend, even putting a comma on any document, then that renders the question, then what am I verifying? That's why he went to the Supreme Court. And the Supreme Court said, we repeat, don't even put a comma, but make sure you look at each and every form and then put them together. So really, the scope of work, the province within which the chairman operates is very confined. On other issues like nominations, there was a decision in 2013 still in the presidential election petition, and there is a portion that had addressed that question. And the Supreme Court had said that in such a case, in a case like the present one, there's no need of nominations. That issue became the subject of another litigation before the High Court. And the High Court stated the law as it is, and it stated there is no need for nominations. So really, that issue is settled. So when it arises before the Supreme Court, I would not want to speculate how it will be decided. But again, my understanding is that there is already a decision on that issue.
All right. Thank you very much, Paul Wathuta. He's a lawyer joining us from the City Center studio. Augustina, before I let you go, let's also discuss the Institute of Democracy. Democratic governance. I think that's the institution that is asking also the court to come in and give direction on, NASA's leaders, as Raila Odinga and Kalonzo Musyoka. On their hand, apparently, they, ensured that, elections do not happen in the different constituencies that they did not happen. Is this a matter that should be before the Supreme Court, seeing that it's not really going after the re-election of Uhuru Kenyatta?
I think I look at the petition of Institute of Democratic Governance, and in their belief, they are saying that the Supreme Court has jurisdiction. A cardinal test in all courts, whenever you take a matter before them, is each and every court has to, for example, respond to the issue of whether it is able or capable of listening to the particular matter, whether it has jurisdictional issues. And in their view, they're saying yes, to the extent that Article 163 of the Constitution makes the Supreme Court the judge or the adjudicator in issues of presidential elections. So they're saying every other issues. In fact, I think in the petition they quote several paragraphs of, I think, paragraph 100 and subsequent ones in the 2013 presidential petition of Raila Odinga versus Uhuru Kenyatta. And they're saying that, the Supreme Court of its own motion actually said that it is not just with regard to a presidential election or with regard to the result, with regard to a petition under Article 140, but with anything else which is consequent and subsequent to an election, a presidential election. So it is not just with regard to petition under Article 140, but anything else that is the purview or within the mix of a presidential election. So maybe the Supreme Court would find that it has jurisdiction and therefore subsequently listen to the issue. But I really think that it is interesting what they're asking the Supreme Court to do. That, you know, they're asking the Supreme Court to find that Raila Odinga, Kalonzo Musyoka, and Senator Wetangula and Orengo committed electoral offenses.
Yes.
You know, one by first saying they're going to boycott the elections,
Yes.
and then after boycotting the elections, they subsequently said that there's not going to be an election. So apart from moving it from a boycott to a threat of no election, and then also mobilizing their supporters to either barricade roads or stop or reject. They show cases, I think, of the Siaya County where there was a training happening, I think in Kisumu as well,
Kisumu,
where
yes.
IBC officials were ejected. So they'd like the Supreme Court to find that the Nasser leaders committed electoral offenses, and you know, having committed electoral offenses, they would like the Director of Public Prosecutions to prosecute. Now, that particular petition might look harmless on the face of it, but I think the detail is what is fairly very dangerous. Because you see, for example, it were to proceed, I do not know how the Supreme Court would judge this, but should they, for example, declare that there are electoral offences that are committed and the DPP opens up investigations and which subsequently end up in a conviction or something like that,
Yes.
or then, you know, part of the penalties of an electoral offence would be, you know, barring you from running in 5 to 10 years. So which would mean, like, you know, all the 5. And I know the petitioners looked very careful in terms of what they were doing, because they listed all, in their view, they thought would have been NASA would be presidential candidates in the 2022 election or a subsequent election, whenever it's going to be. So it might look very harmless on the face of it, but I really think the detail is where you really need to pay a little bit more of concern and attention to.
All right. Thank you very much, Agostino Neto. He is the former immediate member of Parliament for Ndhiwa constituency and also a legal-minded lawyer. Thank you very much for your time.
Thank you very much.
Great insights there. All right.